I'll make sure. Good afternoon, everyone. We're about to get started in 1 second. I am going to record before we get started. So, good afternoon, good evening, everyone. I am super excited that you all are joining us this evening. It is my pleasure to have Crystal Richardson with the Law Office of Crystal Richardson on this afternoon. She's going to be talking to us about how to future proof your legacy. So, welcome, Crystal. We're super excited to have you. I'm
Thank
going to just You are so welcome. I'm going to do an introduction and just tell you a little bit about Crystal before I turn it over to her and allow her to kind of just talk to us about how do we future proof our legacy around the how, the why, and the things that you need to know around estate planning. So, without further ado, Crystal Monique Richardson is the sole member of the Law Office of Crystal Richardson PLLC in High Point. Her principal area of practices are estate planning, estate administration, and heirs property law. She has a passion for serving individuals and families and preserving their legacies and navigating the complexities of the legal system. Drawing on her knowledge of property law and descendants' estate, she has a niche heirs property practice dedicated to succession planning for heirs property, resolving title issues, and securing ownership rights to their land. Ms. Richardson is a member of the estate planning and fiduciary and real estate law sections of the North Carolina Bar Association. She also serves as a member of the sections Inclusion, Diversity, Equity, and Access, or the IDEA, and legislative subcommittees. Crystal is also a member of the National LGBTQ Bar and the Guilford County Bar Associations. Ms. Richardson received her BA from the University of North Carolina at Charlotte in 2006 and her JD with pro bono honors from the Charlotte School of Law in 2011. And I am so honored and thankful and grateful that Crystal is joining us. Crystal and I had the pleasure of meeting through Thrive High Point. So she is a fellow Black woman, small owned business. So I am super excited to have her on to support my platform and also just to talk about something that I think is definitely a huge need in our community. So I'm going to turn it over to Crystal so that she can share, just all the wonderful things that she has going on.
Well, thank you, Dr. McKiever. I'm very excited to be here working with you, the McKiever Group. I've been following all the wonderful events and things you've got going on, and it's just an honor to work with you. And I'm really grateful to have you as a community member doing that work. So just special place in my heart for you. And thank you for that beautiful introduction. You said all those big long words, but really I'm a death and dirt attorney. What does that mean? I help people plan for death. I help administrate estates, and I help people plan for succession of what to do with their property should something happen to them, and just, care for them during their lifetime. So I'll share a little bit more about my practice areas and the estate planning, which is why we're all here today. But just wanted to uplift that I am licensed only to practice in North Carolina. So I serve clients all across the state. I have a virtual office, although I am physically located in High Point, as you mentioned earlier, Dr. McKeever. And, again, very passionate about the advocacy work that I've done in the past, and really try to bring that into my practice, because I do think having access to information and legal services is really important to the community. I would be remiss if I did not say my own legal disclaimer that this is information for the community tonight, because I am passionate about being here. I, recently started swim lessons. I didn't tell you this, but I recently started swim lessons, and I'm missing a swim lesson tonight because I want to be here with you all talking about estate planning, which is just, again, critical to our community. And so, with that, just know that I am not offering legal advice. If you have specific questions about something that you have going on with you, with your family, you need to consult an attorney and have a one-on-one consultation with them so they can best advise you about your specific circumstances. But I will hopefully be able to answer some of your general questions tonight. And again, share with you about why is it important? Like, what is an estate plan? First of all, why is it an important? Why do I keep hearing things about avoiding probate? You need a trust, put your property in a trust. What does all that mean? And I don't even think I have enough assets. I hear that a lot too. So why would someone who is like me need an estate plan? I'm young. I'm not going to die anytime soon. I don't need that. So we're going to flush all that out because there are many, many myths out there about what estate planning is, what it does, and I want to hopefully debunk some of those myths, and provoke some thought and some questions about what you may be experiencing specifically. And hopefully, if you haven't already done your estate planning, you do something that starts today. All right. Okay, so tonight we just had the introduction. We'll talk about what is estate planning, why do we need an estate plan, what happens if you don't have an estate plan, and whether it is advisable to create an estate plan on your own. And if you can't afford to work with an attorney at this time, what are some things that you can do within your means to start working on your estate plan? And then we will open up the floor for questions, and hopefully I've got some answers for your questions. All right, let's get it. So, what is estate planning? Estate planning is the process of arranging for the transfer of your assets upon death, but it also is arranging your assets during your lifetime to the person or the persons that you desire to benefit from your estate. A thorough and comprehensive estate plan will also minimize your tax liabilities and costs associated with administrating an estate. We all know that death is inevitable for everyone. So it's important not to avoid thinking about what happens if something happens to you. And not only at death, but what if you had a life-changing event? You are temporarily or permanently unable, physically able to work. Who's going to care for your bills? What if you can't communicate your healthcare wishes and desires? Who do you have in place to be able to make those decisions for you? And it's not just about who you trust and who you want to do these things, but also backing that up with the proper legal documentation so that they can actually take action and do things on your behalf. The simplest way to create an estate plan is to create a last will and testament, but I'll talk about some other methods and tools that you can use to do your estate planning. And then I'll also explain what is the difference between a will and a trust, and which would be more appropriate perhaps for your situation. All right. So some common goals of estate planning. Number one, we generally have an idea of where we want our assets to go if something happens to us. We know for some of us, we want to give certain assets to our children or grandchildren, or some of us want to give items to our chosen family, our friends, those that have been significant members of our community in life. And so we want to make sure that that property that we have worked so diligently during our lifetime to accumulate, it goes somewhere to the proper hands that we seem fit for that desired purpose. Also, protecting your assets against losses from poor management or the propensity of certain family members to maybe dissipate that property before you get to reach certain goals that you have for that. So let me break that down a little bit. Poor management and propensity of certain beneficiaries to dissipate that property. That means that some of us have family members that may be in active addiction or just not good with a windfall of money. And we want to make sure that they're cared for, but we know that if it might be a concern if these assets were to get into their hands, that they may deplete those assets a lot faster than the time it took you to accumulate them. Or you may have certain goals you want to pass it on to certain people for future generations. And if they deplete those assets, there may be nothing left to pass on. Estate planning can also be used to avoid or postpone the payment of estate or inheritance tax, or taxes that may be attributable to any property and its income. You can also achieve certain desired outcomes for the property owner, for beneficiaries, for their beneficiaries. So that means that if you, for example, want to use the property that you have for your beneficiaries for, the future use of your family members, or maybe you have some community endeavors that you want your property to be used for. It may be used as a mechanism to speak for you when you can no longer speak for yourself. Another goal of estate planning is ensuring the transfer of interest in closely held businesses to the appropriate beneficiaries, while providing the equivalent values and other assets to be made available to other beneficiaries. Some of us are business owners, and our family is the staff and employees of those businesses, and so we have a closely held business where our family members are also owners, or may be vested in interest in these businesses. So we want to think about, especially as the primary person, usually a matriarch or a patriarch of the family, who has this family-owned business that you all have had in your family for years, and you're working to kind of incorporate the younger generations into the business ownership model, and thinking about what happens to the business if that leader who has primarily ran the business, something happens to them, if they become incapacitated, for example. So you may use some of these tools to be able to navigate your transfer of interest in your business, closely held businesses. Another important goal is reducing the shrinkage of the estate values. When we all pass on, your executor of your estate has to evaluate your assets. And so some of these assets could be diminished in value, or you may not get its full worth as it passes to beneficiaries if it's not properly managed or cared for in a properly comprehensive estate plan. Another important goal for estate planning is providing a mechanism for managing your assets. I know many of my clients come to me, they may be tenants in common of certain property that they have inherited from a parent, for example, and all of them might have, a different idea about the goals of management for that property. Having a written agreement about the management and who makes those decisions, as well as a plan in place if something happens to any one of those owners, would be vital to, again, maintaining that property and making sure you get the full value for that asset. Estate planning can also do things like name a guardian if you have minor children. And then, to me, the most important thing is that it minimizes chaos and confusion among the surviving family members, those that are trying to grieve and make some really tough decisions about what to do. It's a lot easier when you've normalized those conversations around death or incapacity, as well as having those legal documents in place. All right. So again, a thorough, comprehensive plan not only cares for you at death, but it also can care for you during your lifetime. And so we want to make sure that you're working with your professionals, your financial planners, your real estate agents, your foresters, your tax professional, your attorney, all of these individuals that can help you make really good, sound decisions, about your assets. And again, these are things that could be generating income that could care for you in case you are no longer able to work, and care for yourself. Or if you just, again, want to retire and move on to some creative endeavors and things like that, you can use estate planning as a tool to harness that generational wealth. And again, there's a number of ways that you can do that. So these are some basic documents that I think everyone 18 or older should have when it comes to their estate planning. So the first one is the last will and testament, and I'll talk a little bit more about that. But regardless, everyone should have a will if you are 18 and over. If you have a trust instrument, for example, you at minimum want to have a will in place that says put everything that I own in my individual capacity into my trust. Have that at minimum. Again, trusts are wills are very, very important. This document not only will distribute your assets upon your passing, but it could provide some very helpful administrative provisions as well that makes it easier for your executor to probate your estate should that be necessary. Then you have a financial power of attorney, and this is a legal document that doesn't have to be, but it can be recorded with the Register of Deeds, and it just lets everyone know and puts everyone on notice that you have appointed an agent to make decisions about your financial and business decisions on your behalf. So if you're receiving, government benefits, for example, you have pending litigation, you've got your bank accounts that you pay your bills out of regularly, things like that. You can name and give those powers to an agent who can take on those endeavors on your behalf. And so they're stepping into your shoes and acting as if you would act for yourself. And this is a fiduciary duty that is very different from them just, making a decision because they think they know what's best for you. So you want to make sure you're picking people that truly understand you and the types of decisions that you would make, understanding your circumstances so that they can stand in your shoes and make those tough, important decisions on your behalf. And then the healthcare power of attorney is something I think a lot of people overlook. The healthcare power of attorney is really, really critical when you can't communicate. And that could be anything from you going to the doctor, for example, for a routine procedure where they've put you under anesthesia. You're not going to be able to communicate your wishes. And so I think it's important to have your healthcare power of attorney document in their file. So if something happens or they need to make an important decision, they know the people that you've chosen to make those decisions for you. The other important thing with the healthcare power of attorney is the advanced healthcare directive. And so that healthcare directive gives guidance to the power of attorney that you've chosen. So if they're making decisions about life prolonging measures, whether to keep you on machines, to keep you alive, or, that may not cure whatever condition that you have, you want to make sure that, they are clear about what you would have chosen. And a lot of times people say, oh, I want to, I don't want to be connected to machines. I want to die with, my dignity, respect, just to have maybe treatment for pain and comfort. If it's a permanent vegetative state that I'm in, for example. And so having that advanced healthcare director where you're authorizing your agent to make those decisions to withhold or withdraw life prolonging measures would be really important. And then the HIPAA release authorization gives the people that you've named as your agent, whether they're co-agents or you have a successive order of agents that you've named, they have the authority to get your otherwise protected healthcare and personal information so that they can make those decisions about the facilities you're in, even being able to pay for treatment. Any release of information, you would need to have this HIPAA release authorization. All right. So we hit on what is an estate plan and talking a little bit about the goals and the purpose of having a good estate plan. So I want to share with you a little bit about why do I need an estate plan? And I mentioned this briefly before, and Dr. McKiever did an amazing flyer talking about building generational wealth. But estate planning is something that could be a great tool for not only building intergenerational wealth, but preserving it, which I think many folks who look like us miss out on. We're the least likely to be able to inherit from those future generations. And that could really be beneficial to doing things like being able to put a down payment on a first home or pay for college tuition and not come out with a bunch of student loans and debt. Some of us are, business owners, and we could use that seed money or that money to pour into our businesses that could potentially be beneficial for our generation and our future generations. So I'm a huge proponent about estate planning, and just wanted to share that we all should be thinking not only about this particular generation, but who are the people in our lives that care for us. And if something were to happen to us, is there something we could potentially leave them that might help make their lives better, particularly financially? And I think that's something just historically we do for one another. We generally care for our family, and we pour into making sure that they're well taken care of. And this is a great tool to be able to do that. It's been said that 1 out of 3 Americans do not have an estate plan, which is unfortunate. And many of them, I would say, from the studies I've read, at least 77% of Black Americans don't plan at all. That's huge. That is huge. 77% is nearly 100. So I think this could be the generation that really changes that. And I understand, people's decisions not to do estate planning. Many of us think that, why do it? The government will create an estate plan for me. Things will go to my spouse or my children already. They're on the life insurance, which is great, but it's so much more than that. Once you really inventory everything you have, just looking around your house, look around the room right now. All this stuff has to go somewhere. Who gets this stuff? So we might as well name who we want, exercise your self-determination and autonomy. Who do you want to either donate those things to, gift those things to? Somebody could absolutely benefit from those things. And if they don't want the items personally, at least it's an asset that they've now acquired that could potentially be sold, and the proceeds might be used for something. Another thing that I think people don't realize is even when you have beneficiary designations, you've got your 401k, you've named your mama and your daughter 50-50. Okay. What happens if the daughter predeceases you? Who gets her 50%? What happens if mom predeceases you? What happens? So it's important when you have these beneficiary designations, do you have more than one person listed there? If not, then it'll go right back into your estate. And we keep hearing all of this talk about avoiding probate. Well, even if you have a trust, if you name someone on your policies and they don't survive you, they're no longer living. So the company, they can't hold that money. It's got to go where? To their heirs? Does it go back to you and your estate? Those are some of the questions you'll be able to answer with your attorney, and you'll be able to put some succession plans in place. Many of my clients that I work with, I have them name at least 3 people. So if it's, they're naming their executor, give me your second and third choice, because I really love to see succession planning. That if you learn nothing, estate planning is about succession planning. What happens when the person in charge is no longer in charge, whether their stuff has to go somewhere or the decisions that they make, who is going to be put in charge of making those really critical decisions? Another reason why I think many folks who look like us don't do estate planning is because of historically, our generational habits. Historically, our ancestors were once thought of as property, for example. And if we were considered property and we, likely as generations have gone on, we've acquired certain assets. So our, mother's mother and their mother haven't done estate planning. It's not something in your family that's regularly discussed, and it's not something that we generally have access to, coupled with all of the, for example, predatory lending practices, lack of trust in the legal system, all of the things. There are so many, again, misconceptions about estate planning, and we just avoid it. We don't like talking about death. We have learned these generational habits, and we just haven't gotten around to it. We don't think we need it because we think we're young. But then when we see some of these younger individuals passing on, we think, oh man, they were just 35. Oh man, they were just 40. They had an aneurysm or whatever the case may be, a horrible car crash. I mean, anything could happen. And we want to make sure that the people who likely will, need these documents, that they have them and they're readily available if these types of incidents happen. And the people who don't have them, who these unfortunate circumstances happen to, usually they're the ones who need them and they just don't have them prepared. So I would rather you be prepared than not. I would rather you, if you have to and you can't, again, there are tools out there, online tools, where you can just answer a few questions and it will spit out a last will and testament or a power of attorney for you. There's lots of clinics at law schools that offer free, documents. And those are a great start. Everyone should, again, have something rather than nothing. But I do think no one estate plan is simple, and that you should be having these in-depth conversations and understand and have them with someone who really understands and knows how to navigate the law, so that whatever your goals are that you think you're doing when you're creating your own estate plan, you're actually doing. Because sometimes the legal effect isn't what you think it is when you use certain language. Sometimes you don't know to include certain language to kind of seal the deal and make sure that you've properly conveyed an asset. So again, have something in place, do what you can, but when you can, speak with an attorney. Likely it's more affordable than you may have thought. I know not many, but some attorneys, such as myself, do payment plans if cost is a barrier. Because again, like I said in the beginning, I do not want estate planning to be a barrier for folks. So what happens if you don't estate plan? I mentioned it before. The government has a plan for you if you don't. And so these are the statutes that North Carolina, what we call intestacy laws or intestate succession, meaning you die without a will, intestate, you die with a will, testate. And so, for example, one of the provisions in these statutes, if a decedent is survived by a spouse with no surviving descendants and they have a living parent, then that surviving spouse gets half of the real property, and the first $100,000 of the decedent's personal property. And the remaining balance is divided between one half the parents and one half the surviving spouse. For some people, they may be okay with that. For some, they might be like, whoa, 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 I haven't talked to my dad in 30 years. He hasn't been in my life. I don't want my parent to inherit from me. If that's the case, you need to legally document your wishes and name the individuals that you do want to inherit from you. Okay. And so, again, just to kind of give an example based on that statute I just read, let's say decedent is the person who dies. So let's say that person who passed on, they had no children and they had one living parent, that dad that they are estranged from. And they also were married. So let's say the total assets they have is $200,000. So that means now that the dad that you didn't want to inherit from you and your spouse will own one half interest in your real property. And then your spouse gets that first 100,000. And then dad and spouse are dividing that remaining 100,000. So spouse would get 150,000, dad would get $50,000 and half your house. How does that sound if you genuinely have not spoken to your dad? And so the statutes go on and on and on. So let's say you are not survived by a spouse, you are not survived by children, a living parent, but you've got siblings who you don't get along with. Or maybe your siblings are deceased, but you've got distant cousins that you haven't even met. So again, intestate succession, the kin, nearest of kin is likely those who will inherit from you. And there's a certain succession that the government has laid out that might not align with your wishes. So again, exercise your self-determination and right to name who you want to inherit from you. So I said that I would talk a little bit about the difference between a will and a trust. So I'm going to take that moment now to do that. So with a will, a person must be of sound mind. They must be 18 or older. They must have an intent to sign the will. And I'll talk a little bit in a second about what makes a valid will, but it can be less time consuming and less expensive. Okay. Note that it does have to be probated. So it is a public document once it is probated, meaning they take it to the clerk's office and they probate your estate. So now anyone can go up there to the clerk's office and request a copy of your file, and they can see exactly if you've made any specific gifts, who you've, what you've given, and who you've given it to. For some people, they would prefer a more private document. So that would be a trust if you are more interested in making sure that your bequests or your gifts do not become a public record. You have to have the mental capacity, which is different from that will of having sound mind. You have to have the intention to create the trust, and you have to name a definite beneficiary. So you can be a beneficiary of your trust. So I create a trust. I am the settlor, the grantor, the person who creates the trust. I am a beneficiary because I wanted to care for me during my lifetime. But I can't be the sole beneficiary in North Carolina. So I add Dr. McKiever. So she and I are beneficiaries, but I am the trustee. Another thing is important. So we talked about fiduciary duties earlier when we talked about power of attorney. Trustee is another one. If the trust is not properly managed and administrated according to that document, you could be susceptible to litigation. Because again, as trustee, you have to act for the care and the benefit of those beneficiaries. Okay, so you have to really understand trust administration, what the laws are, and so forth. It can be revocable or irrevocable, meaning you can amend it, you can do a reinstatement, you can terminate it. And there are various types of trust. Some, for example, are like a supplemental or special needs trust. There's charitable types of trust, trusts for your insurance policies, for example. So there's a number of different types of trust that you really can't determine the type of trust you need unless you really understand your purpose for creating the trust and the specific goals that you have. It is more time consuming to create, and it is likely more expensive. And again, it's private, it's not a matter of public record. Okay. And so I also want to mention here that when we talk about avoiding probate, a trust is not the only way to do that. You can also have non-probate assets where, for example, in your bank accounts, you name a beneficiary, what we call a POD, payable on death beneficiary. So if something happens to me and I want my assets to go to my best friend and my colleague, I can name them 100% to my best friend if she survives me. If not, then 100% to my colleague. You can, for example, on your vehicles, go to the DMV. Me and my friend Jane Smith are on this vehicle title with rights or survivorship. So if something happens to me or Jane, the survivor of the two will be the sole owner without having to go open up a probate estate. So again, a number of things that you can do with your probate assets. Those probate assets will be things that you individually own. So any cash on hand, any checks owed to you, any, your vehicles, your household furnishings, those are things that are considered probate assets. And honestly, I don't think anyone can genuinely guarantee that probate can be avoided because again, you may have your trust created, but if you haven't properly titled a certain asset into the trust, it's going to go through your probate estate. So again, avoiding probate might also look like using your trust instrument, having a will, what's called a pour over will that pours over your assets into your trust. You have your beneficiary designations on your IRA, your 401k, your bank accounts, and you've named those beneficiaries. Those are the things that you're going to need to do if you are interested in avoiding probate and minimizing costs. And so in North Carolina, what makes a valid will? And I bring this up because we just kind of heard about, for example, Aretha Franklin. She had what's called a holographic will. She had the second one here. And it was a valid will entirely in her handwriting, but she had three different versions. And, at first, honestly, they didn't know where to look because those wills kept kind of coming up. She had one in her couch, for example, that was found later. So 3 or 4 years of litigation trying to understand or determine which of these wills is the valid will and making sure that it is a valid will in accordance with the law. And so North Carolina with handwritten wills, yes, you can do that, but there are certain rules around handwritten wills that need to be met before it is determined or deemed to be valid. So most people work with an attorney, draft a will that has what's called a self-proving provision. So we don't have to verify your handwriting. We don't have to verify your signature. It has two witnesses that have notarized, have their signatures notarized along with your documents, which is what makes that will valid. And then the nuncupative will is an oral will. So this is very specific circumstance, very rare, but it's made orally by a person in their latest sickness or imminent peril of death and who does not survive such sickness or peril. And it's declared before two witnesses, competent witnesses, simultaneously present. So that's a lot of elements you have to meet for this to be a valid will. Okay, and it's generally documented after what that person's wishes were. All right. So just to kind of go back and sum up, what can you do now to get started on your estate planning? You can do things like add beneficiaries to your bank accounts. You can add joint tenants with rights of survivorship to your vehicle titles. Beneficiary designations, check them. Sometimes we get jobs and we don't look at those documents for 20, 30 years. And we're like, oh, that person passed on. that was my ex-husband, or someone I no longer talk to. So check out their beneficiary designations, who you've named down on your IRA accounts, your life insurance policies, your 401ks, and so forth, and make sure they're people that you would want to inherit from you today. And then if something happens to them, can you name a second and a third option for their portion if something happens to them? And then this is my favorite as well. I've been kind of exploring, like on Facebook, for example, you can add a legacy owner. So, I've named, for example, my spouse to take over my social media account, because there are memorial accounts and different, things that we have with Instagram and all the other platforms, where someone is going to have access to that account and either shut the page down or continue to manage it in a way that honors your memory. And so to be able to have access to that, these entities that own these social media platforms are going to need verification that you are the person that the owner has deemed to take over if something happens to them. Okay. So there are ways to get started. Again, a will is also very, very vital to catch all of your assets that you have it specifically named to go to any one person. We could talk about this for, I don't know, for on and on and on for eons. There's so many things that go into estate planning, but I will stop here and see if there's any questions.
Thank you, Crystal. So if you are in streaming on any of the social media sites, you can drop it, and you can drop any questions that you may have in the chat. I think we have one person here on the Zoom with us. So if you're on the Zoom and you have questions, you can drop them in the chat, or you can come off of mute if you like and ask, but we will give people a few seconds to see if anybody has any questions. And then if not, I'll ask you a few follow-up. And someone said you can have a will that pours over into a trust and it's one document. So yeah, and my fun fact, Crystal, is once upon a time I used to work in trust. I spent 6 years working in philanthropic trust at a large financial institution. And it was so funny because I remember when I took the job, I had no clue, like you always hear personal trust, and I had no clue that there was this whole thing of charitable trust. And the guy was like, I can teach you nonprofit. He was like, nonprofits, I can teach you trust. And I remember going in, and it was just like so wild that there was this whole charitable entities, and like you said, kind of the trustee and having that fiduciary responsibility. So I'm just gonna steer gears for a little bit, because I think this is also an important conversation. And then we do have a question in the chat that I'll come back to. So with charitable trust, like Crystal said, that is also a estate planning tool. It's also a tax planning tool for you to be charitable. And like she said, I worked specifically with more kind of those charitable remainder trusts and those charitable assets. But we had a lot of people that would set up a trust or a charitable gift annuity. They would name themselves for the beneficiary. It would typically be a period of time, right? And you receive that benefit, and then that trust would, disband, or those charitable institutions or your church or whoever would receive it. So I just encourage you, because everybody knows my background is philanthropy, that as you think about estate planning, that if you do have, it's a charitable component that goes to this as well, that can be beneficial in offsetting things. So if I'm an Aggie, and I know Aggie pride is strong across the globe. So like, for example, if you have affinity for North Carolina A&T and you wanted to leave them in your will, you could reach out to their planned giving department. Most higher ed institutions have those. So just think about, when you think about estate planning as well, that's also a charitable tool. You can give it to your church or your faith-based institution, and of course they would welcome those type gifts. So Crystal, that's just kind of my little charitable spiel.
And I have had a client who was an A&T alum say that they wanted to do that. So I was honored to be able to help them include that into their estate planning, which is always, pretty cool when people give back to those philanthropic causes.
Right. So
Mhm.
the question we have in the chat is, can you talk more about the lifetime benefits of having a trust? And we kind of talked a little bit about that now, but definitely go into it from your legal perspective.
Hmm. Yeah, so in the trust instrument, we talked a little bit about what makes it valid. And when I mentioned beneficiaries and you being a beneficiary of your trust, you can certainly add provisions that say, number one, who are the successor trustees if I am incapacitated, which is extremely important. But then also list provisions of what any income generated from the trust could be used for if you are deemed incapacitated, and kind of have a priority. So you, as the creator of that trust, we might prioritize, you would be the grantor. So we might prioritize the grantor's needs. And then if there are other needs of other beneficiaries, that they might come second to the grantor, for example. But those provisions can absolutely care for your medical expenses. If, for example, you need long-term care, your trust can talk about, how you want to be cared for in that way as well. So you are still living, of course, but again, you've got to have certain things that provide you with care, whether it's, making sure you have a roof over your head, how are your bills going to be paid? If you're in a long-term facility, who's going to pay for that sort of thing? And then making distributions, how often, is it monthly distributions that you are entitled to, or quarterly, annually, those sorts of things? Because if you aren't able to make those decisions, and the trustee role shifts from you to your successors, again, we want to make sure those terms are very clear about how to care for yourself. And so if you have provisions that talk about what happens during your incapacity, how are those funds that the trust generates, how are those funds to be used, your successor trustee has to follow those terms and make those distributions accordingly. And so that again is a method of how it can care for you if you are incapacitated or something happens to you.
Thank you for that, Crystal. If anyone else has any other questions, now would be your time to drop them in the chat. And Crystal, while we're waiting to see if anyone else has any other questions for you, I guess my last question would be kind of what would be your advice or takeaways for someone if they, may not, be ready to go meet with the attorney to get everything in order? Kind of what can you start doing today to prepare yourself around getting your estate in order just in case?
Mm-hmm.
Kind of like the poor
And
man's
that's why I
version.
like to end on this slide, because these are things that I think are very feasible for a lot of people. And then, like I mentioned, there are some online tools where you can maybe purchase a package to do some very kind of general, simple wills where you're naming certain beneficiaries at minimum. You can name specific items, if you've got your grandmother's ring, or, some ancestors, unique, china or dishes or things like that. You want to give specifically to certain individuals, but everything else is called your residuary estate. And so at minimum, you want to be able to say, I want this person, A, B, and C, to have, you know, 50% of my assets, the next person to have 30, and the last person to have 20. So we know exactly the percentage of your total net worth. Where does all of that go? Some of those assets that pass on might be liquidated, and the proceeds may go into your residuary estate, or the specific item might become a part of your residuary estate. So you want to be able, at minimum, to have a document in place. My only concern is that making sure that when you use these online tools, that they're executed properly, because it will be for naught if you again, don't have that valid will instrument. And then worst case scenario, like I mentioned before, you can do what's called a holographic will. And I've worked with an estate that has probated a holographic will where it was entirely in the person's handwriting. They just took a sheet of paper, wrote down what they wanted. That is fine. But again, know that you may not account for all of your assets, and there may be other steps where your loved ones are trying to prove that that was your handwriting, and some other obstacles that might make that a valid will. But at minimum, again, have something in place. Start with these beneficiary designations, naming individuals that are important to you, that you want to have the major assets. There's certain like wills clinics, for example, at various law schools across the state. That's another great way to get some estate planning, at least done by an attorney that could be free of cost or very minimal cost. And then there are other attorneys such as myself, and I'll put my contact information here, that will work with clients who may have some financial barriers. If you can't pay all at once, we may be able to establish an estate plan. And then, like I said, worst case scenario, there are institutions like Legal Aid of North Carolina that you may be able to reach out to as well. The North Carolina Bar Association is another one. But there are a number of ways to get started.
Awesome. Thank you. And my last question to you before we wrap it up is, in the world of scammers, like what is it that people need to be aware of? Because I know, like you said, you do have a lot of these, oh, you can go to legalzoom.com and fill out information. But like you shared in that one case, certain things have to be notarized and in presence of, a notary with two signatures. So if you just had to give people some things that you would just kind of be wary of, what would those things be kind of going forward to make sure that you're not getting scammed or, giving information to somewhere it doesn't need to go or vice versa?
Yeah, I would say only give your information to an actual attorney. So you can look any attorney up in this state or other states at the state bar, and you can certainly see if their license is active in your state or not. So that's the first thing. But a lot of these online tools, like the ones you just mentioned, you just are kind of inputting the information, and then it creates the documents, but it's still on you to be able to execute them. And so I would be aware of that, first of all, because that is an additional step that you're going to have to take. And so you're entering your, private information into these systems. So make sure it's a valid platform that you are using to be able to produce these documents. But again, if you really want to be safe and not just kind of entering your information, I would say work with an attorney. And then I think you did have one question, Sharita. I did see that you had your hand raised earlier. Did you have a question as well, if we have time?
And we do have time if she has another one.
Okay. Okay, maybe not, but I wanted to offer that before we close out.
Awesome. Well, Crystal, thank you so much for your time. Do you have any closing thoughts or anything you want to leave with the people aside from y'all go follow her on Instagram? You're on Facebook too, right?
Yes, absolutely. The Law Office of Crystal M. Richardson, PLLC. I would say the key takeaways from today is that life is unpredictable. We've absolutely, have to take time to think about what happens in these unforeseen circumstances. No matter what age you are, it really has no age limit. And it is challenging to think about sometimes. I myself struggle, about who to name to take on my assets. But we get to a place where we have to know our worth. We have to really, really think about what we have, and get out of that myth, that mindset is, I don't have anything to give. Oh, this stuff doesn't mean anything to anyone. If I had $1 for every time I heard that. But it absolutely is important, because there's more problems than not when you do nothing. and allowing again the state government to make your decisions for you. To me, it's just an unfortunate event, you know, especially when we've worked so hard to acquire these things in our lifetime. So when you're ready, I would say maybe start with an inventory, a list of all of your non-probate and probate assets. And just start thinking about, you know, who do you want to have your stuff? Who could benefit from it? A charity, a friend, a neighbor. And then maybe the next step might be thinking about who you would want to make important decisions for you. Think about who are those key people that you genuinely trust. And once you have that information, if you're ready, go to an attorney, a law clinic. Find some resources online where you can start really legally documenting your wishes, and make sure you check on that every 2 or 3 years to make sure it's still a good document. You might need some updates as life progresses. So those are my final thoughts, but I really hope that you got something out of this presentation. It is time for us to really utilize these tools and build on that intergenerational wealth. So I, again, will leave you with that. Thank you so much for allowing me to speak to you about estate planning today.
Thank you again, Crystal. You know, my passion is lifting up other Black women and so especially Black women owned business. So this was super important for me to have this conversation. And I really appreciate Crystal just, you know, coming on and sharing her insights for free. So I hope, like she said, that someone took something away from this. It's recording. It'll also be live streamed. It actually should be available on my Dr. Shinika McKiever YouTube page, Facebook, and LinkedIn. I think the video's a little wonky on Instagram, but the sound is there. But yeah, this will be available immediately after. I hope that you will choose to share this with your network. If you do need attorney services, Crystal is located here in High Point, but like she said, she works across the state of North Carolina. So please go follow her. You can follow me on my Dr. Shinika McKiever page. A few upcoming things that I have going on. Next Friday, we will be at Transform Greensboro hosting the Building Holistic and Inclusive Community Symposium. So hopefully you can join us there. It's going to be a jam-packed day with hands-on work sessions around building engaged community. So you'll leave with kind of a strategic roadmap, and we've got some excellent speakers. So I will all that information is on my page. I'm also excited to announce that I will be launching a lunch and learn for Black women on Juneteenth. So I'll be getting details out for that in the next, probably this weekend, but that's going to be super exciting. And we'll be talking about kind of taking up space. And the whole premise of that lunch and learn is giving Black and brown women a space to be authentic and show up about the things that we just kind of deal with on a daily basis. So super excited to, you know, continue to be able to curate these spaces for our people. And then, of course, I will be on June 14th partnering again with Rakita Brown to do the full day live Rise and Thrive Women Wellness and Leadership event. So the details will be releasing later this week for that as well. Crystal, I'm sure we will partner again to do something. But again, thank you so much for your time. Y'all, please support her. And if you have any additional questions about estate planning, you can find Crystal at Crystal Richardson, the Office of Crystal Richardson Law on Instagram or Facebook, or you can email her or reach her via her contact information there. So again, thank you all for taking time out on your Tuesday evening to chat with us. And Crystal, I'm so gracious for you sharing your knowledge, and you just continue to do wonderful things in the world. And thank you so much for your support. Y'all have a great night.
Bye bye. Have a good night.